Welcome to the DMH Stallard Employment Group podcast. My name's Abigail Mayno. I'm a partner in the employment team here at DMH Stallard. And this is the third in a three-part podcast on globalisation in the world of work. In our first session, we looked at inward recruitment to the UK. In our second, we looked at short-term or more ad hoc remote working arrangements. And in this final session, we're going to be looking at some of the issues and potential benefits associated with engaging employees on a more permanent basis to work abroad. This topic has become increasingly more important for employers as we become more connected from a technology perspective, post-COVID, employers embracing remote working to unprecedented scales, and employees really driving, wanting to relocate and work on a more global perspective. So in this podcast, we're looking at what are the benefits, what businesses need to consider from a legal, tax or immigration angle. And we've got a fantastic panel with me today to discuss some of these issues. We have Adam Williams, head of the immigration team at DMH Stallard. Since 2008, Adam has been assisting UK employers to get the most out of UK immigration system. And he also regularly advises international businesses on the immigration aspects of inward investment to the UK. Simon Bellum is also joining us. Simon is a partner in the employment team at DMH Stallard. He spent the last 35 years supporting a variety of clients, including those with overseas operations. And finally, we are delighted to be joined by Sanjukta Ray, Employment Tax Solutions and Global Mobility Manager at Menzies LLP. Sanjukta advises clients on employment tax matters relating to globally mobile employees. She has a wealth of experience in the tax and payroll aspects and implications of cross-border working. So, Sanjukta, looking at it from a tax perspective, is it possible to have a sense generally of how long you would need to be in a location before you trigger some of the sticky tax issues and presence?
It isn't really. I mean, I know we talked about the more sort of temporary moves and the ad hoc working holiday type moves in the second podcast of the series. But even for those arrangements, there really is no de minimis below which it's safe to say that there's absolutely nothing for the employee or the employer to consider. Therefore, for permanent and long-term or more structured moves, these sticky issues relating to immigration, tax, etc., would come into play from the get-go. And one would ideally have to start planning and start thinking long before these arrangements are actually finalized. Now, there is a common belief that if somebody is spending less than 183 days in a country, that individual or the employer will have nothing to worry about from a tax perspective. This can be a very dangerous assumption to make and is often incorrectly made by people. I mean, you would have to meet quite a few conditions for that so-called 183-day rule to apply in the first place. And even if it did apply, it may not completely exempt the employer from carrying out their sort of reporting obligations overseas. So, I mean, and that might be the case, even though there might ultimately be no tax for the employee or the employer to pay. Now, having said that, the implications will vary depending on the facts and circumstances of sort of every individual scenario and overseas jurisdiction concerned. And every country, I mean, realistically, at a practical level, they will apply rules differently. So we'd have to bear that in mind when we are planning for such moves.
Yeah, just chipping in there, Abby. I totally agree with Sanjay. That 183-day thing is a myth we need to dispel, because I see that, and Sanjay must see that a lot.
Yes.
So if there's one of the takeaways from this discussion, that it's important not to convince yourself that there are these bright lines of separation and that every scenario is going to just fall within that rule.
Absolutely.
It's really invariably not the case.
Yeah, and I think the 183 days, and correct me if I'm wrong, is when you start to potentially lose your tax residency in the UK rather than having tax obligations in another country. Sanjukta's going to see, you're going to correct me on that?
Yes, not really. Well, 183-day rule.
You're trying so hard to agree with Abby, Sanjukta. How can I find a way to say yes?
You can disagree, Sanjukta. This is what the podcast's for.
Well, broadly, yes and no. I mean, it is to do with losing and gaining tax residency, but it's not quite simple as that, because we're talking about double tax treaties, and if you spend more than 183 days in a country, you're definitely tax resident. But there could be other implications even if you did not. So I mean, yeah, I mean it can get quite confusing, and if you rely on that 183 days, it can be quite dangerous.
Yeah. So the key takeaway is dispel that myth that there's any magic. There's any magic to the number of 183 days.
Yeah.
So
it's going in room 101.
Yeah, absolutely. 183 and 101.
Yeah.
So Simon, what about employment rights? So local employment law rights applying. What's the position on that and the choice of law? Is there a particular length of time you could spend in a country that would make that more or less important or determinative in terms of whether UK law continues or ceases to apply and local law takes over?
Okay, well, the question of which employment laws apply, I mean, it's complicated, is the first thing to say. And there's a mixture, really, of things which happen automatically and things which you've got a level of control over, and where you can use the contract to choose the law that will apply. So if we take a quite common example of somebody who's been UK based, already employed by an organisation, but is going to go and work overseas, I think there's two things to be thinking about that might happen automatically. One is you've got to be thinking about, okay, they're currently a UK employee, they've got UK employment rights, they're going to work overseas. What happens to those UK employment rights? Will they retain them or will they lose them? And the other thing you need to be thinking about is, right, they're going to work overseas. Will they acquire any of the employment law rights that exists in the country where they're going to be located? So if we take the first question, well, what happens to the UK employment rights where somebody goes to work overseas? This is where it does get complicated. The courts have always struggled and chopped and changed in terms of working out, well, what level of association with the UK has to continue to exist for the employee to retain their UK employment law rights. And maybe the picture is best evidenced by a recent case where the Employment Appeal Tribunal came to the view that an employee who was UK based, who went to work overseas in Australia purely because they were able to work remotely, so they were doing it for their own convenience. The Employment Appeal Tribunal concluded that they retained their UK right to bring a claim of unfair dismissal, notwithstanding that they were working on the other side of the world. And they identified a range of factors that might be looked at to determine whether or not the connection with the UK remained sufficiently for the employee to retain their UK employment rights. So they were saying you look at where the employee is based, any choice of jurisdiction that the parties make, and I'll go on to talk about that in a bit more detail. What was said to the employee about their employment rights, where the employee was managed from, where the employee's home was, where they were paid and in what currency, where did they pay tax, where was the employer registered, and also whether there's any connection between the employer and the UK state, some government or public body. So you can see that there are a mixture of factors that are going to be taken into account in working out whether the individual retains their UK rights. But there's particularly that scenario where people simply are going to work overseas because it suits them to work remotely. There's high risk that they will retain their UK employment rights. And then the next question is, right, what about an employee goes overseas? Will they acquire rights that apply in the country where they're going to be working? And the probability is that they will. because it's well established that there are mandatory employment rights which an employee will have, regardless of what the parties try to do in terms of writing the contract and excluding those rights, that they will have, which apply in the local country. And the importance of that is maybe best demonstrated, rather than looking at all the local employment rights in all the various countries in the world. If you just look at the mandatory laws in the UK that apply to people working here who are previously based overseas, all of the rights under the Employment Rights Act, such as right to redundancy payment, right to claim unfair dismissal, all the rights under the maternity and discrimination legislation are those mandatory rights. So if you transfer that position to an overseas country, there may well be a host of employment law rights that are relevant in that locality that will apply to the individual who's been posted overseas. So those are kind of things that you've got limited control over, in the sense of they're going to apply depending upon the circumstances of the employment and that list of factors that I was talking about. Then the other big question is, okay, well, what about if you write something in the contract of employment that says UK employment law will continue to apply, or some other jurisdiction, or you say that any disputes going to be heard in the UK legal system? They can be of importance. We can see that they can be taken into account in deciding what jurisdiction is going to apply. And the courts will have quite a high regard to the choice of law, choice of jurisdiction that the parties record in the contract of employment, but it will always be subject to those mandatory rights, which will always apply. So there's limited discretion that employers have. You asked the question whether how long they spend working overseas is going to be relevant. Yes, it is. It's going to be one of the questions, one of the issues that will be looked at by the court in working out whether there's a close connection with the UK, so that UK employment law rights still apply, or whether there's a permanency with the overseas posting, such that the UK employment rights don't apply, and other mandatory rules do apply.
And the thing is with this, Abby, is sorry to cut across you. You get what that can mean, Simon. I'm sure you've seen this. Is you can end up looking at the situation and you can take advice to the nth degree and try to get clever legal opinions and ways to try and manage it. But sometimes an employer has to look and understand both sets of rights and laws and accept that in theory they could be battling on two different sets of grounds, and in a different way and in a different timeline to Sanjukta's considerations around tax, payroll, etc. You're looking at risk management, to even if it's in a loose sense, the longer the person is there, the greater, broadly speaking, the likelihood of the local rights applying. So, okay, what are those rights? Be comfortable as an employer that we'll let it go on that long then, and that probability keeps going up. One regime, sure, Simon and Sanjukta, you've probably been on the edge of seeing this advice around employment rights, may actually be a lot more expensive than another in terms of an exit, for example. If you think of, if I think off the top of my head of Italy as compared to UK with redundancy type, Sanjukta's nodding, you can look and go, goodness me, these are not even comparable. It's not like, oh, well, whichever forum they choose, it will broadly end up the same. It won't. And in fact, you can't even be sure they'll only choose one. You might be battling both. Someone might try and,
Really good point, Adam. So that's a terrific point, that sometimes the employee can get the best of both worlds. So you put in the contract of employment that UK employment law will apply, but the mandatory rules in Italy, in that example, also apply, and the employee gets the best of both worlds. They get the benefit of the mandatory rules, which might be more beneficial in Italy, but they'll also be able to say, well, for other purposes, that jurisdiction clause applies, so that I'm entitled to bring a claim for some other employment-related right or some other right under the contract in the UK.
Yeah. I think it goes back to something we've said, even in the first of these series about planning and just getting to the corners of the pitch in terms of what the potential exposure in the worst case, potentially might be for the business before agreeing to anything that might potentially be long-term and tip a business into those risk levels on all fronts, just getting a handle on what the exposure might be, and if the business is comfortable with that from a theoretical perspective, whether or not it ends up transpiring.
Yeah, that's absolutely right. I think Sanjit Wolf have seen this as well, in the sense that for a business, how can you do your sort of cost benefit analysis if you don't have a sense of what the potential worst case risk scenario is? This move in ordinary circumstances has got to make sense for the organization, in the sense of it works, it adds value. And ideally you want to weigh that up, don't you, against the downside risk? Well, you could go in blindly and just say, we don't know what the risks are if it all goes wrong, but you can't then do a reasoned assessment of, well, Sanjukta says this is the tax implication in the worst case scenario, and Simon says this is the employment, and Adam's saying these are the visa issues. Let's hold those up in the light against the positives of this move, which could be as simple as we just really, really value and need and want this person, and they want to make the move, or it could be, no, strategically we're pushing for the move and we need to say, do we or don't we? But how can you do that if you don't know what the broad, as you put it, corners of the picture? Yeah.
So we've had some views on some of the tax considerations, some of the legal implications. But Adam, is there any distinction between sort of more flexible short-term working arrangements for people visiting a country as opposed to longer-term moves from an immigration perspective?
Yeah, okay. Well, the answer is almost certainly yes. As most of our answers will be premised with, it depends on the territory you're looking at. Answers to lots of your questions will start with that. But subject to that point, it depends in terms of precise requirements the country you're looking at. Yeah, almost certainly, because short-term trips might have been done on an understanding that though the activities the individual is going to do work-wise are permitted of visitors in that location. If you looked at the inbound UK scenario, do a lot of that, there's actually quite a broad set of business visitor permitted activities. To an extent, some people might be quite surprised with examples of what you can do. I mean, they're specific, but they have a range of different activities. But when you get to a longer, more permanent stay, it's probably fair to say it's unlikely in most jurisdictions that the visitor rules are going to allow longer term, we've used this term sticky, haven't we, more local-based activity. I mean, if you took the UK example, again, you can't take up employment or self-employment and be doing a job from the UK. You still have to be essentially someone that would be recognised as visiting. So that's the key thing. We have to think about nationality of the individual within that context, because broadly speaking, if they're going to be based in Spain and they're Spanish, then you shouldn't have an issue. But outside of that, you've got this question of immigration control. If the visitor rules, we're moving away from visitor, well, what are the permissions that are needed? How do we ensure that they and we don't get on the wrong end of immigration control here? So it could mean, if you took the UK model as an example, and there'll be a different version or approach in other countries, but very, very commonly, you will need a business registered and set up in the UK, and having established itself in order for that to happen through a work visa. So query whether that's the case in this country that you're now looking to move someone to.
Yeah, absolutely. And Sanjukta, presumably that has a knock-on effect on potential tax reporting if you've got to create a presence in that jurisdiction and other obligations.
Yes, these seem to be quite closely linked. So what might be needed to facilitate immigration may then trigger employer reporting obligations from a tax perspective. So for instance, what I was going to say earlier was that in a normal sort of permanent move, or if you're hiring somebody permanently overseas, you would expect that the employer would have a payroll withholding obligation to calculate income tax, social security, what have you. But if that foreign employer did not have a presence in the overseas jurisdictions, sometimes they could be exempt from operating a payroll. for income tax purposes, and they would still have to sort of do something to meet the social security obligations, but sometimes those can be moved on to the employee themselves. But if you're now creating an entity or creating a presence to meet immigration requirements, the employer will not be able to get itself exempted from that payroll withholding, reporting, operating obligation. And there will, of course, be other things to consider, what would be corporate tax reporting, corporate tax paying obligations. So yeah, one would lead to another, and it kind of, yeah,
there's a bit of a snowball effect, isn't there?
Exactly. Yeah.
On the issue of social security, I understand in the past there was a need to get certificates regarding which country's system would apply from a social security perspective. Do employers still need them, and what's the risk of not having them, and the employer's liability if they don't have those certificates in respect of both countries?
So for moves that are completely permanent, the certificates of coverage or the A ones are not relevant, because if somebody's moving somewhere permanently and that's where they're going to live and work from, then it's that jurisdiction social security regime that will apply. So you don't need a certificate to say that that person's then tied to their home country or previous home country. But for shorter, even though they are structured moves, shorter moves like secondments, the 2 or 3 year assignments, then yes, they're still very much needed. I mean, they would typically allow an employee to remain covered under their home social security regime without having to also contribute into the host. So if you, if you did not have a certificate of coverage when you should have, then you, although you might still be contributing into the home system, you will find that the employer and the employee both has a need to also make contributions in that overseas regime. So you'd have a situation where there's a double contribution because you're paying somewhere where you shouldn't, but you haven't paid where you actually should. So yeah, it's still very much.
Does that still apply in the context of doing a business trip as well?
Again, it's never, there is no de minimis. They don't say that you don't need a certificate if you stay below X number of days. So we typically tend to advise that you should get certificate. I mean, it's how the overseas authorities might want to enforce it. I mean, post-Brexit, I would expect there to be a bit more scrutiny if you're going to the European countries. They might insist on a certificate for even 1 day's business travel. So it's advisable to have one. I mean, it's not always possible because business trips by their very nature can be quite ad hoc and you don't know. But you can backdate it. Application.
I guess it might come down to the employer taking a view on the chances of the authorities picking up on an issue for a very short business trip.
Yes, and also sometimes if you're, I mean, going away from business to more sort of longer term moves, I have seen some overseas authorities request a certificate at the immigration application stage. So not sure why they would need it, but they insist, please produce a certificate of coverage for your immigration application to be filed.
That's really interesting.
Yep.
It's probably an indirect way of trying to sense check that this is a genuine business managed kind of controlled trip rather than it's because the immigration authorities are most concerned about allowing people over the borders who are coming for different reasons than they say. And so that would be one way of saying, all right, you're telling me that you're employed by this organisation, you're coming on a business trip. This is one way of you backing that up. They'll have an A1, won't they? Of course, the employer might not, because they go, no, what's an A1? We never even thought about it. We didn't think that if it was under 183 days, there it is again, that you had to have one, you know?
So Simon, just linking back to what you mentioned earlier about the contract taking you so far, but local mandatory laws potentially creeping in regardless of what you might have in a contract. Is the contract important at all in all of this? Is it possible to ensure that only English law applies and you only end up in English courts as an employer? I mean, I think the answer to that is probably no, based on what you said earlier. So, is there any value in employers looking at their contracts when someone's moving abroad?
Yes, there is still a value. You've summarised it nicely there, that you can't be certain that by stipulating in the contract of employment that UK law will apply and that the UK courts will have jurisdiction to determine any disputes. You can't be certain that that's going to hold good. But it will be one of the things that's taken into account when the courts are looking at the issue of whether or not there's sufficient proximity to the UK. So the choice of law that's made by the parties and which is recorded in the contract of employment, it remains important. But I think the underlying message is that doesn't matter how many times you write that it's UK employment law that's going to apply, or it's the UK courts that are going to determine any issues, there will be mandatory rules in all countries abroad that will continue to apply. And that's very, very clear. It's worth making the point that there are two issues to address in the contract, and they are separate issues. One is the question of, okay, which law is going to apply? That's the governing law point. And the second separate issue is which courts will have jurisdiction. So those are two distinct issues, and they both need to be addressed in the contract.
Yeah. And is that true of immigration rules as well, Adam? Is the contract important at all? And can it be used to avoid local requirements applying?
It's broadly true. It's broadly the same, but really, in that it can be valuable, but in a slightly different way, I think. I mean, it's correct to say that you can't use the contract to control and force a different immigration requirement or outcome than that which applies. So there's no point thinking that as an employer, well, we'll say that this is a visit and therefore US immigration authorities won't be interested. If the person's going in and doing things that the US authorities are going to go, that is not a visit. So please come with me. So you can't use it in that sense, but quite often it's important in the sense of different immigration routes will require the individual, the business, to demonstrate that the arrangement under which this is taking place, and it has to be, if you look at the UK scenario, it may have to be a very specific type of arrangement in how it's been set up. So you do have to have that element, and the contract is usually an important part of maybe more than one document that has to set that out. Okay,
so we might be the death of a 183-day myth, but not the death of the contract. Is what we're saying.
Let's not accidentally throw that one in room 101A, Simon.
Absolutely. I think there's one other point that's worth making in relation to whether or not you exercise a choice of law within a contract. And that is that whilst we're very clear that there are mandatory rules that will apply where an employer is working overseas, those mandatory rules might cover areas such as I've described, what happens on termination, unfair dismissal rights that exist abroad, redundancy rights, holiday rights that exist abroad. But we know that the contract of employment covers a whole host of other things, and there might be other areas which aren't governed by the mandatory rules that apply locally. And a typical one might be something like restrictive covenants. So what you could have is a situation where, okay, that choice of jurisdiction and choice of law clause within the contract doesn't disapply the local mandatory laws in relation to areas such as notice, redundancy, etc. But where there are no mandatory rules, for example, in relation to issues such as the application of restrictive covenants, then the choice of law clause would be relevant and useful. So that's another good reason for using the choice of jurisdiction, choice of law clause.
Yeah, really good point.
Yeah, absolutely.
I was just going to ask a question, really, Simon, where, we're talking about mandatory laws, and then the UK might have similar laws, but they might be more or less favorable than the overseas ones. Do you have a choice which mandatory law? Well, I suppose you don't. If they're overseas, those rules will apply. But if the UK laws are more favorable, for the same set of mandatory laws, say parental leave or what have you, does the employee then have a choice to say, well, I'm going to make use of the employment laws in the UK because they're more sort of favourable or more generous?
Yes, yeah, that's the risk, that the employee gets the best of both worlds, so that they can rely on what the contract says. So supposing the employee is wanting to rely on UK laws and the contract says UK law governs this contract, then they can say, all right, I'm going to rely on that clause. Yeah, please pay me the more beneficial arrangement that applies in the UK.
Yeah, certainly a lot to think about from a choice of law perspective. Sanjukta, probably just sort of now we're bringing this to a close. This might be a silly question, obvious question, but is there a significant difference from a tax perspective when somebody who might have been working for you in the UK, let's say, wants to move to France on a more permanent basis, versus someone the business might recruit locally in France to do a role? Is there any particular difference in terms of tax obligations there?
Well, the difference would be in that the person that is moving from the UK will have a UK connection. That is, they will have been a UK employee on a UK employment contract, subject to UK PAYE tax and national insurance. So when they move, they and we are assuming that they remain an employee of the UK company, they will have a trailing UK PAYE obligation. So, the employer, at least in the short term, will have to carry on deducting tax, national insurance, and so on. But then also there'll be an obligation in the overseas jurisdiction to sort of run a shadow or a secondary payroll to deal with local laws. Whereas if you're, and there's a little bit of sorting out to do in the interim, or at least in the short term. Whereas if you're hiring somebody who's never been to the UK, but is going to, say France, is going to live and work from France, then it's cleaner from UK perspective. There's no connections to the UK. You don't have to worry as much about what happens to UK tax, because there's nothing to worry about. You wouldn't have any UK tax. You only have to worry about the French aspects. Okay, there might be some, for accounting purposes or reporting purposes, you might still need to show the employee going through your books in the UK company, but you don't have the PAYE issues and the double tax issues to deal with again in the short term.
I think I would chime in there, Abby, as well, that it can have a bearing on the immigration position. I was
just about to say that, Adam.
With colleagues, and anecdotally, I recall, because I don't try and become an expert myself in all these different jurisdictions, but we'd looked at this for a move to France, and it was a different immigration route and visa option if you were transferring someone as opposed to locally hired. So that's a really good example of how you've got your advisors looking at these different factors. Sanjukta and I would need to put our heads together and work out with the client, are there options here on either side, and which one's going to win the day in terms of driving you down a particular route where you've got more than one way of doing it.
Absolutely. I mean, it's really clear from our conversation so far that there's a real layering up of the three different areas in terms of the legal, immigration and tax that all have to be looked at and considered in the round as to, as you say, Adam, which is going to be the driver for an employer making a decision. I think probably just to close, it'd be useful for the listeners if we could get one takeaway from you all in respect of tax, payroll, local labour rights, immigration in this context. So if there was one takeaway from this session for our listeners, what would it be? So I'm going to pick on Adam first.
Get out of the way. Get out of the way. Fine. I think it would be, don't forget about immigration, first of all. It will almost certainly arise as an issue unless the person is a national of the country they're going to be in. And as a takeaway, at the very least, make sure you've got a sense of the visitor entitlements and, most importantly, limitations. Where is the boundary line between something that is accepted as a visit activity and one that steps you over into, no, this is something you need proper permission for?
Okay, very good. Sanjukta?
I'm going to
your takeaway?
I'm going to echo what Adam says. So don't forget, for people tend not to forget about tax, but they tend to think about it quite late in the day. But permanent moves typically don't happen overnight. So in theory, employers and employees both should have plenty of time to consider all the risks and come up with a plan or solution that works for both the individual as well as the employer. So yes, do step back and take time to think through the relevant issues and assess what needs to be done before making an informed decision. So plan ahead, really.
Plan ahead. And last but by no means least, Simon, your key takeaway?
Thanks, Abby. I would say local employment law rights. Don't assume that just because you're saying in the contract that UK law applies, that you've avoided overseas rights. It's highly likely that there'll be some mandatory laws, significant number of them, that will apply locally. And you need to do your research. You either need to obtain local legal advice, we can always put people in touch with overseas lawyers, or alternatively, you need to look pretty hard on Google if you can do it yourself.
Absolutely, with a big disclaimer on the Google advice.
Absolutely,
yeah.
That was a really interesting conversation. Thanks to all of you for taking part. I'm sure our listeners will have lots to take away. So this concludes the last in our series of 3 podcasts on globalisation in the world of work. I hope that everyone has found it useful. Do follow us and get our latest updates and next podcast wherever you get your podcasts, Podbean, Spotify, and Apple Music. So thank you very much for listening.